please the court.
Yes.
I was nearly at the end of ground 2, and I'm going to go back there if I may, but can I just pick up 3 very short points from this morning? That arose. Firstly, just to clarify 1 or 2 points. Firstly, in answer to the point from my Lord Justice Mayles, as your Lordship will know, the usual way in which one seeks to say or establish one's liability to third parties to point to a judgment, an award, or a settlement. Cases such as Post Office Union and so on will demonstrate that's what you do to crystallise your loss. Now, we have no evidence as to what extent it's permissible under Iranian law to challenge a judgment or an award. But what we would submit is this, that the usual inquiry when a party has made a payment, in other words, suffered a loss as a result of an award, a judgment, or a settlement, is that the inquiry relates to whether or not that party acted reasonably, either in assuming the liability did under the agreement or in not challenging the award or not appealing the judgment. So the focus is very much on the reasonableness of the claimant's conduct. And that's very different, we would submit, from inviting a tribunal for jurisdiction over one contract to make a determination as to the existence and extent of liability under a separate contract. That's the specific point that arises in this case, which we say is outside the jurisdiction of the tribunal. The second point, my Lord, is questions about how you approach the analysis of Iranian law and whether or not a question of construction of a contract by reference to Iranian law is a question of fact or not. And as far as the approach is concerned, can I just remind you there's one passage which is not unhelpful in the Tribunal's award, which is in Core Volume 2 at page 291. It just gives you a flavour into how Iranian law works. Page 290, paragraph 379. Each side called an expert witness to support its case on Iranian law. As would be expected, there is a substantial area of common ground. Iran is a civil law country. Written laws, typically in the form of codes, provide the answer to most legal questions. Custom and usage may be relevant. There's no system of binding judicial precedent. The writings of learned commentators can play an important role in legal interpretation. The role of Islamic law and its relationship to the civil law was discussed by the experts. The differences on that point appear to be a matter more of emphasis than conflict, and so on. Also, my Lord, there is a passage in the core supplemental. It was in our skeleton argument for the learned judge below. It's not in our current skeleton, but it's not unhelpful just to show it to you, Lordship. It's in core supplemental bundle. Tab 7, page 214. This also goes to the point my Lord Justice Nugee raised with me about the role of an English judge when construing a contract governed by foreign law. So paragraph 35.6 of the skeleton argument before the learned judge on page 214, or supplemental bundle, tab 7. The role of a judge considering foreign law evidence differs from his or her role in assessing ordinary evidence of fact. In the being a lawyer, she will normally bring their legal training to bear on the issue to be decided. However, the corollary of this observation is that where the foreign law in question is significantly different from English law, or equivalent, there is less scope for a judge to apply his or her own knowledge and training. In those circumstances, the judge should consider the evidence of foreign law in the same way as other evidence of fact. The same point is also made by the authors of Phipson, paragraph 33-93. The court should be wary of falling into the trap of looking at issues of civilian law or even Islamic law from the perspective of the English common law. What may be perfectly understandable to a practitioner in a civil law or Islamic law jurisdiction may sometimes appear surprising and odd to those not familiar with such systems. So any sense of oddity that Iranian law has the policies and principles which we've identified, in particular the restrictive approach to the construction arbitration clauses, should not be treated as a particular surprise, given the fact we come from a common law heritage. Also, my lords, I should say, although I can't provide you the answer now, but we'll try to do so in the morning, because I'm told there is a very recent decision of the Privy Council, published, I think, in May this year, which may well touch upon the point my lord.
Yeah, it's called Perry.
Ah, indeed, that's the case we have in mind. I'm afraid I haven't had a chance properly to read. Perhaps my lady knows it already, but I think there is some useful guidance in there that may assist. But as I say, I'm sorry to say I haven't been able to digest it. But if it's helpful, we can provide you with a copy.
That I think was, well, my lady obviously knows it better than I do, but something to do with where there are concurrent findings in the courts below.
I think that's right.
But it has some comments that are actually not inconsistent with the passage you've just taken us to.
My lady, it's not directly on point, but it may well give some guidance. It talks about there being a spectrum and so on, and between the different types of law that is being considered. I mean, obviously, if you're considering New York law, in a rather different position if you're considering Iranian law, we would respectfully submit. But the key point here, my lord, is this. I think this goes to the question my Lord Justice Nugee asked me about questions of construction in the context of summary judgment applications, and in what circumstances it may be appropriate to grasp the nettle, so to speak. And the point here is that it's important to have in mind the distinction between the role of a trial judge and the role of a judge hearing an interlocutory application for summary judgment involving a question of construction. Now, the role of a trial judge is he may be confronted with a situation where the two constructions that he is confronted with, which are being advanced by each party, are plainly arguable. And the task of deciding which is correct may not be easy. But at the end of the day, the trial judge has to make a decision. Which one is right? Now, that, in my respectful submission, has to be contrasted with the role of an interlocutory judge, even in the context of a case of construction, as illustrated by the AC Ward case, that even in a case involving English contract, where the question of construction is arguable either way, in other words, it's not clear that one side is bound to fail at trial, even if the judge thinks he knows what the answer is likely to be, or even if the judge has formed his own view as to what the answer is, that being not a proper basis, in my respectful submission, on which to refuse permission to defend or to allow a case to go to trial. What we submit, that proposition is doubly true, or explicitly true, so, in cases where the judge is confronted with the task of construing a contract that's governed by a foreign system of law, which by definition is involved, or at least involves a question of fact, and the ultimate decision itself may be one of fact. Because in those circumstances, given the inherent limitations that any evidence foreign law is going to have at the interlocutory stage, in particular the fact it's not been tested by cross-examination, places the judge in circumstances where, unless he can be satisfied that the foreign law is either inconsistent internally, in other words, it's obviously wrong, or is plainly irrelevant, unless he can be satisfied of either of those circumstances, then the ordinary course, particularly in a complex case such as this, would be for the matter to proceed to trial. In our submission.
You've identified the two stages. So first of all, identify the Iranian principles, and then for the judge to apply them. And I certainly understand you say the judge went wrong at stage one. His summary or distillation, you say, was incomplete. And if you're right about that, then so be it, whatever consequences follow. But if the judge was right at stage one, which after all is the only place where there would be scope for more evidence, whether experts' memorandum or cross-examination, do you say he went wrong at stage two in applying the principles which he had identified, if they were the right principles? And if so, how did he go wrong?
My Lord, I do precisely that, and that is essentially ground 2 of my appeal. And again, if I haven't made this clear, I apologise profusely. But what we do say is, if you look at the judgment, which has been called...
The literalistic as distinct from restrictive.
Quite.
Yes, all right. Well, we understand that.
So so even if the judge was right to distill the 3 principles and ignore everything else, when it came to applying those to the contract, we would submit in 59, he clearly went wrong. He went wrong in a number of ways, but one way in particular he went is he didn't even apply his own principle, namely
Yes, I understand that.
And what we also say is that it's plainly arguable, we would submit, in a case where there is a presumption that a clause is being construed restrictively, in a system of civil law such as Iranian law, and where there's not been any cross-examination, that it'd be, unless that law is shown to be obviously wrong, then the appropriate course would be to allow it to proceed to a trial.
Yes.
And what I try to develop as best I can why we say, in any event, the learned judge was wrong to say that the words relating to have a wide and a broad meaning. We've made the point that that's not true as a matter of English language in any event. See the old cases. Secondly, the proper interpretation of relating to will depend upon the, as Lord Hoffman put it in Fiona Trust, the attitude of the courts, and as we say, the policies and principles underlying the system of law's approach to arbitration agreements. And when you look at the policies and the principles that are identified by Dr. McCramey, they are hugely important because they point the way towards, we would submit, the words relating to it to be given a narrow construction which would not encompass a dispute between arising under a separate contract with a separate arbitration clause and a separate system of law as to whether or not there was in fact a liability and to what extent it extended to under that contract as being within the scope of the arbitration agreement. At the end of the day, what the judge did is he expressed his view on what he thought the right answer was at the end of the day. What he should have done is asked whether or not our client's, Neox case, was arguable, and indeed whether or not it could be said at this early stage, without the full benefit of cross-examination and joint memorandum of Iranian law, that he could be satisfied that our case on construction was bound to fail. And we submit that had he asked the right question, he should have answered it no, it wasn't bound to fail. Well, that's what we have to say about ground 2. If I could then move, unless there's a question on ground 2, I move to ground 3. Now, this is a point concerning paragraph 59.3 primarily, although the same point, as I mentioned earlier, pops up in other parts of the judgment. The point here, my lords, and my ladies, that when he approached the question of construction, he actually asked himself the wrong question. As well as adopting the wrong principles of Iranian law, he actually asked the wrong question. And the question he asked is, and it's most explicitly expressed at 59.3, what is according of old here is to ask whether the clause, in referring to arbitration of all claims arising out of or relating to the GSPC or its breach, extended to a claim which might in the future be brought by one of the parties to the GSPC for damages for its alleged liability. Now, my lord, the reason that's the wrong question is we don't dispute that it did extend to such a claim. The important point here is that a claim is not to be equated with a matter within the meaning of section 31C of the arbitration agreement and section 67. We've dealt with this, my lords, in paragraph 22 to 23 of our replacement skeleton, our main skeleton for this appeal. Perhaps that's the easiest place for me to show you these points. I think they're expressed more clearly there than I can do orally. This is the section of our skeleton argument, section C, matters relevant to this appeal. paragraph 21, section 31C of the Act provides, unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction, that is to what matters have been submitted to arbitration in accordance with the arbitration agreement. And in other words, that provision gives the tribunal its competence jurisdiction to rule on what matters fall within the scope of the arbitration agreement, in other words, on its own substantive jurisdiction. And the important point is what we say in paragraph 22. While the word matters plainly includes claims, it's more appropriately to be understood as meaning or including issues. And we say that, we refer to a dictum, but it's not reason, so it doesn't take it very far. But Sir Michael Burton said, the issue for 31C is my judgment whether an issue is arbitrable. But we make more substantive points across the page. Firstly, the fact that the substantive jurisdiction of an arbitral tribunal in relation to a claim or cause of action may be narrower or different than that of a court. And there, of course, we refer to the usual problem with set-off, which is a conundrum that's been going for many years. Then perhaps more significantly, paragraph 3, the fact that a single claim or cause of action, which would be fully within the jurisdiction of a court, may involve or give rise to certain issues which are within the jurisdiction of the arbitrators and others which are not, depending on the scope of the arbitration agreement. And then the important footnote is footnote 14, and we can either look at it, we can look at it in the bundle rather than that quote, but that's the relevant passage. But the Ruhan case is in the bundle, and we can look at it. It's in volume 4 of the authorities, tab 48. It's the decision of Mr. Justice Popwell in the context of an application for a stay under Section 9 of the Arbitration Agreement. But the relevant paragraph which we submit is helpful. And if I could pick it up, my lord, at page 1143 of the bundle, paragraph 37. Or rather, perhaps paragraph 36, just to set the scene. There are two stages to the inquiry which the court is required to make under Section 9. The court must first determine what the matter or matters are in respect of which the court proceedings have been brought. Sorry, I should just pause for a moment just to explain. Section 9 is the provision which mandates the court or requires the court to stay legal proceedings which ought to be within an arbitration agreement. That's what we're talking about. So the court must first determine what the matter or matters are in respect to which the court proceedings have been brought. Secondly, the court must then determine in respect of each such matter whether it falls within the scope of the arbitration agreement upon its true construction. So much was common ground. However, the parties' submissions differed on the approach to determining what the matters were for the purposes of the first question. Mr. Kaplan submitted that matter in Section 9.1 is to be equated with claim or cause of action, and that the fact that a defence is raised which falls within the scope of the arbitration agreement does not mean that Section 9 is engaged if the claim itself does not fall within the scope of the agreement. Pausing there, that's not far away from what how the judge seemed to approach the question in our case.
Presumably Section 9 refers to the concept of matter, and that the judge is discussing it in that.
Well, I perhaps should show you, it may be set out here, but...
it's paragraph 34.
34 it's set out, yes. So paragraph 34, my lady, at the very top of the page we're looking at. It is in the bundle too, but it's quite useful because it's set out on the same page. So Section 9 provides a party to an arbitration agreement against whom legal proceedings are brought in respect of a matter which under the agreement is referred to arbitration may apply to the court in which the proceedings have been brought to stay the proceedings so far as they concern that matter. So that's the language used in Section 9.1. When you compare it to Section 31C, which is the section which explains the substantive jurisdiction of the tribunal, which I believe is in Authority Bundle 5, thank you, at tab 54, and at page, what page? At page 1269, section 31C, or rather the whole section is relevant here. 30, competence of the tribunal to rule on its own jurisdiction. Unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction, that is to say, as to, and then little c is the relevant one, what matters are being submitted to arbitration in accordance with the arbitration agreement. Now, our simple point is that the word matters in section 31C and matters in section 9 have the same meaning.
Sorry, I'm probably being very slow. Can you show me how section 30 works with the provision that we're looking at?
Well, it works
Section
because if you go to section 67, section 67 is what we're dealing with, challenging the award. The party to arbitral proceedings may, upon notice to the other parties and to the tribunal, apply to the court challenging any award of the arbitral tribunal as to its substantive jurisdiction. See that in section 67(1)(a). Then what does substantive jurisdiction mean? Well, we find that out from section 31C.
I see.
Substantive jurisdiction is what matters have been submitted to the arbitration in accordance with the arbitration agreement. And then I believe there is a definition provision at the end of the Act. Yes. So I think it's page 1327 of bundle of authorities bundle 5. So the last entry under section 82(1) in italics, substantive jurisdiction in relation to an arbitral tribunal refers to the matters specified in section 31A to C, and references to the tribunal exceeding its substantive jurisdiction shall be construed accordingly. So, my lady's quite right, it's all a little bit of a jigsaw, but you need to put the various pieces together. But when you
so you say when construing section 67, with that definition in mind, you've got to look back to 31C. That's what you say.
Certainly when you construe 67, the word substantive jurisdiction have to be construed, or rather interpreted by reference to the definition in section 82, and that takes you back to section 31C, which refers to what matters have been submitted. And what I'm submitting to the court is the word matters in section 31C doesn't mean claims, or it certainly doesn't only mean claims, but it includes issues which arise in the context of a cause of action or a claim. And that's because that's the same meaning as applies to section 9 where the word matters is used, and because section 9 and section 67 are basically two sides of the very same coin. Because under section 9 the court is saying which matters fall within the jurisdiction of the arbitrators, and under section 31C, competence, the arbitrators are saying themselves what matters fall within their jurisdiction. So they're two sides to the same coin. And the point I was on is that certainly in the context of section 9, matters doesn't just mean claims. And this is dealt with, as I was going back to paragraph 37, Mr. Justice Popplewell's judgment he then was, I was showing you Mr. Kaplan's argument that it's to be equated with claims. And the learned judge goes on behalf of Mr. McNulty and Mr. Cooper, Mr. Eadie argued that what was meant by a matter was an issue, and that the search for it was for issues which were the subject matter of the arbitration agreement. The learned judge accepts in due course Mr. Eadie's submissions, but the point here is the analysis by which he did so. And one can see it paragraph 42 at the bottom of page 1144. On the other hand, the dispute between the parties may be well defined before any proceedings are commenced, with clear identification of issues and sub-issues by reference to different causes of action and different defences. Commercial disputes often involve more than one cause of action and a number of alternative or cumulative defences in relation to each. It is right to observe that the problem being considered arises in the context of what will often be a dispute involving multiple issues. Even a single cause of action may involve some issues which are arbitral and others which are not, depending on the scope of any potentially applicable arbitration agreement. And then he gives an example, but the proposition is contained in that sentence. But the example he gives, this will be so, for example, in the case of a claim in the tort of conspiracy to injure by unlawful means, where the unlawful means are breaches of a contract between the parties, where the arbitration clause on its true construction applies to contractual but not tortious disputes. Moreover, the grounds for disputing a claim may involve a completely different set of facts and legal principles from those involved in the claim itself. Defences of compromise, discharge, estoppel, and limitation provide obvious examples. So does transactional set-off, arising out of a different contract. And then in paragraph 43, he sets out what the proper approach should be. So, as a matter of principle, the approach should therefore be as follows. The court should treat as a matter in respect of which the proceedings are brought any issue which is capable of constituting a dispute or difference, which may fall within the scope of the arbitration agreement. And little 3, the court should stay the arbitration proceedings to the extent of any issue which falls within the scope of an arbitration agreement. The search is not for the main issue or issues, or what for the most substantial issues, but for any and all issues that may be the subject of the arbitration agreement, and that's the case even if it leads to fragmentation. But the key point, my lords and ladies, from this case is that it's not enough to ask, in the context of a dispute as to substantive jurisdiction, is the claim in a global sense, or the cause of action within the scope of the jurisdiction of the tribunal. Rather, the question is, are the relevant matters, which may be issues or sub-issues within the context of the cause of action, within the scope of the arbitration agreement? And as we've always said, there's no dispute that the claim for damages by Crescent is within the scope of the arbitration agreement. The matter which is beyond the scope of the arbitration agreement, in our respectful submission, and which the judge failed properly to address, is the dispute or the difference as to the existence and extent of CGC's alleged liability to CNGC under a separate contract, governed by a separate system of law, with separate terms and a separate arbitration agreement. I also
can I just be sure I understand what you've just said? You said there's no dispute that the claim to damages is within the arbitration agreement. So we have three parties. Your client, call it A, Crescent, call it B, and CNGC, call it C. You accept that in the arbitration between A and B, between your client and Crescent, B's claim for damages is within the scope of the arbitration agreement.
Yes.
That claim for damages, as you showed us this morning, consisted of two parts. There was the part that was B's, Crescent's own loss of profit, and you accept that that was properly arbitrable. No issue about that.
No issue about that. Certainly no jurisdictional issue, yes.
And the claim to be effectively made whole, indemnified against what B, Crescent, said was its liability to C.
CNGC, yes.
Yes.
C, yeah. Now, that claim, in a conceptual sense, is, or the cause of action, is within the jurisdiction of the arbitration agreement.
You accept that the cause of action is within this?
Yeah, there's no reason why it wouldn't be. I mean, it's a claim for breach of...
It's a claim for breach of... It's a claim for damages and breach of contract between A and B. Yeah. So that's within the arbitration agreement. Yeah. Your point is that you can't answer that claim. The arbitral tribunal can't answer that claim without looking at the sub-issue of what is B's liability to C, and you say they can't do that in Iranian law because that's not being referred to.
Absolutely, my lord. That issue or that difference as to the existence and extent of a liability of B to C under a third-party contract is not an issue within the scope of the arbitration agreement.
Well, I'm not clear to what extent your analysis differs from the judge's analysis, which is what he says in 59.3 is what is involved is to ask whether the clause extended to a claim which might be brought, because he's looking at it at the time of the arbitration agreement, so it might be brought by one of the parties, in this case B, Crescent, for damages which that party alleged had sustained by reason of its liability to a third party, CNGC.
Well, my lord, that's a description we would submit of the cause of action. What it doesn't describe is one of the matters that arises that's necessary to determine it, which is the fact that Crescent had to ask this tribunal to determine the existence of and extent of a liability on the part of a third party to them under a third party contract with a different system of law and a different arbitration agreement. That's the matter which forms a constituent part of the cause of action, which falls outside the scope of the arbitration agreement, in our respectful submission.
I understand entirely what Mr. Justice Popplewell said in his case, that you can have a claim which contains some issues which are arbitrable, and so that they can be stayed under Section 9, because Section 9 prevents you from litigating something which you've agreed should be arbitrated. But where it is agreed that a particular cause of action falls within the arbitration agreement, it seems a bit odd to say that the tribunal can't actually get to the bottom of that claim, because there are bits of that claim which aren't within their scope. If you say the claim for damages is within jurisdiction, how can they, as it were, stop halfway through the analysis?
Well, as I said this morning, it's not a matter of stopping halfway through, in the sense that they could either adjourn it until such time as a loss is crystallised, or they could consider, as I say, subject to what Iranian law says, but certainly in an English law context, one could consider some form of declaratory relief. But what I think Mr. Justice Popplewell's decision assists with is demonstrating you sometimes can have circumstances where a single cause of action has issues arising in it, some of which are arbitrable, some of which are not. So in other words, you may have a situation where you end up with fragmentation, or a situation where one tribunal cannot resolve the whole issue. The example he gives is a claim for unlawful
conspiracy.
Yes,
conspiracy using unlawful means, where the unlawful means in breach of the contract.
So you may have a situation where you can bring a claim in court for the tort of unlawful conspiracy, but you can't ask the court to determine that, because the question that as to whether or not there's been a conspiracy depends upon an issue concerning a contract which is subject to an arbitration clause. So you may end up with fragmentation. It doesn't mean the matter's never going to be resolved. Obviously, if and insofar as a claim by CNGC ever materialised and there was a judgment or reward, that would move the goalposts.
Or a settlement.
Well, I made one or two observations about that this morning, but yes, in theory, yes.
Well, the curiosity here is we now know, which the tribunal didn't, that there has been a settlement. So if you accept that they could have stopped by saying, well, we'd declare an in-principle liability, and now we know there's been a settlement, does that not follow that now we know there is a liability?
Well, we don't know, in fact. The settlement agreement's not before us, it's in a different arbitration. Apparently it doesn't say there's an admission of liability, it only says that we'll pay what we can recover. There may well be an argument about the effect of the settlement agreement, I don't know. It's not in evidence.
We don't have it.
But what we have, and all we need to do is rather than say, well, now the position's moved, what we're concerned with is what the tribunal actually did in the state of ignorance it was in 2021, and whether by acceding to the invitation, which is what Crescent did, it invited the tribunal, said, I haven't admitted liability, there's no claim, there's no judgment, there's no award, but I'm inviting you to look at this third-party contract I've made. It's governed by a foreign system, a UAE law, different arbitration agreement. There's no disclosure from CGNC. They're not part of the arbitration agreement. But I'm inviting you to look at that contract and make a decision as to whether or not we are liable under it, which essentially is exactly the role we would submit that the arbitrators under that contract would have. And it's not, I mean, the actual arbitration agreement, we haven't actually looked at this, but the arbitration agreement in the contract between Crescent and it's the CGNC, which is in core supplemental.
It provides for arbitration.
It does. It provides for arbitration,
and the law is UAE law.
The law is UAE law. And also, it has a very interesting additional clause within it, which you don't often see. Tab 3 of the core supplemental bundle. So it has page 5 of the core supplemental. It's 21.1 provides for UAE law. 21.2 arbitration. All disputes, controversies, or claims that may arise between the parties at or in relation to this contract, or the breach, termination, or validity of the contract shall be finally settled by arbitration in Sharjah, in accordance with the international arbitration rules of the LCIA, by 3 arbitrators. That's a fairly normal provision. The next sentence, in my submission, is somewhat unusual, although I'm not giving evidence about that, but certainly, and the court, my Lord Justice Nails from his own experience, but this sentence, no matter relating to any such dispute, controversy or claim shall be referred to any judicial or other authority for any action which could interfere with or result in the imposition of any additional procedural or other limitation on the initiation or conduct of any proceedings in accordance with the rules, or render unenforceable an award made pursuant to the rules. That's somewhat significant. I mean, one can easily imagine a circumstance whereby the tribunal in the NEOC Crescent arbitration makes an award which provides that Crescent is liable to CNGC for X amount under that contract. That award is then is enforced and entered as a judgment in various jurisdictions around the world. A subsequent arbitration takes place pursuant to this arbitration agreement. Awards published, which is different from the award that Crescent has managed to enforce in various jurisdictions. Then there could well be a problem with enforcing that second arbitration award because it would be inconsistent.
Sorry, who are you assuming that the first award is enforced against? Because no one's disputing that C in the ABC situation is not bound, not a point.
No, C's not bound, but equally when it comes to enforcement, there may be an issue about inconsistent judgments. You tend not to be able to enforce inconsistent judgments. And I'm just, by reference to this clause, I can't speculate what the position around the world is. What I am saying is a general proposition. One could see that by having 2 tribunals, which is what we're effectively talking about, concurrently, basically having jurisdiction to decide the same issue, then the possibility of inconsistent judgments or results is, we would submit, self-evident. And that can have an impact at the enforcement stage, even if they're not binding.
Isn't this slightly unreal? My understanding is that CNGC is 65% controlled by Crescent. Is that right?
65%, I believe, is right, yes.
So, doesn't Crescent... I mean, the likelihood of there being an arbitration between Crescent and its subsidiaries, I would have thought, vanishingly small. All Crescent needs to do, if it has an award against NEOC, is agree with its subsidiary that is the quantum of its liability to the CNGC. I mean, that's the purpose of bringing this claim is to recover money from NEOC for the benefit of CNGC, isn't it?
Well, the purpose, I'm not sure what the purpose of the claim is. The question is, what is the legally coherent basis on which it's brought, whether it's sound as a matter of law or Iranian law, and whether it falls in the jurisdiction of the arbitrators. Of course, the purpose of Crescent was to get as much money out of NEOC as possible. The original claim was, well, let's treat Crescent as one big group and just claim the whole lot. So the purpose was getting the most money they could out of NEOC, but that was unsustainable. So they then tried to reconfigure the claim to make it legally coherent and say, well, actually, we're liable to CNGC. But the problem with that was that they had no settlement, no judgment, no award, no admission no agreement, no payment. So that's why they had to ask the tribunal to actually go out of its way and assume the role, essentially, of the Sharjah tribunal and make a decision as to what the liability was under that contract. And that's what we say, as a matter of law, exceeded the jurisdiction of this Crescent New York tribunal.
Can I just try and understand what ground 3 adds to grounds 1 and 2? Ground 1 is that the judge conducted a mini trial and shouldn't have done so. If you're right about that, well, the appeal succeeds. Ground 2 is that the judge got the application of Iranian law wrong because he should have applied a restrictive instruction which would have resulted in the conclusion that the existence and extent of the liability under the CNCG contract was not within the scope of the arbitration clause.
Or at least arguably so.
Arguably so. Now, if you're right about that, then again, you succeed. But ground 3 is that there is a distinction between claim and matter, but the only point of that distinction, as I understand what you've been submitting so far, is that the matter does not include the extent and existence and extent of the liability under the CNCG contract for precisely the same reasons as you submitted under ground 2. That is to say, Iranian law adopts a restrictive interpretation,
Yes.
etc. So what does the distinction, which with respect sounds a bit like dancing on the head of a pin, between claim and matter actually add?
Well, my lord, they are independent errors in this sense, that we would submit that had he asked the right question, namely as a matter of Iranian law, is the matter, i.e. the determination of the existence and extent of liability under a third-party contract within the scope of the arbitration agreement, and he asked that question, then it would have been even more self-evident, based on the evidence of Dr. Makrami, that the answer was no, or at least arguably no. Whereas simply to ask yourself the question, is the claim, which is what he seemed to do, is the claim a matter which is outside the scope of the arbitration agreement? The answer to that, at one level, would be no, it's not, which is the answer he gave. But it seems that he may have done so by reference to the wrong question. In other words, when you focus on that particular matter, namely the determination of liability under a third-party contract, it becomes much easier to understand why, in fact, there are real concerns as to why the New York Crescent Tribunal should be deciding that. Because it's clearly a matter falling within the jurisdiction of another tribunal, clearly a matter involving CNGC, who aren't parties to the arbitration, and it clearly gives rise to a risk of injustice, windfalls and inconsistent decisions, which is a matter of Iranian law, are policy considerations which lead towards a restrictive interpretation to avoid those risks materialising. So my submission, it is an important point of principle, and it reveals a further error on the part of the judge, if I may respectfully say so. And it shows that this part of the judgment, which is relatively short, it's the fag end part of the hearing, if I put it colloquially, and he dealt with it relatively briefly, and there were a number of errors, of which this is one, in the sense he asked himself the wrong question. I do need to tell you, my lady, that there is one important case on this topic you should be at least aware of, which is Mozambique and Credit Suisse. It's at volume 3 of the authorities bundle, at tab 31. And it's a decision of the Court of Appeal, so it's not...
Can I just ask before we go there, was it part of your submission below that there was an important distinction between claim and matter?
Yes,
that's in your skeleton.
Yes, it was, and I obviously dealt with that when we argued the permission to appeal.
Yeah. Okay.
But I can give you the references to where it is in our skeleton before the learned judge, which is Core Supplemental Bundle. Tab 7 of Core Supplemental Bundle. And the relevant section is page 192, so paragraph 6 onwards, which is called Relevant Legal Principles, section 31C and 67 of the Arbitration Act. And we set out section 67. I set out the provisions which I've referred the court to.
Yes,
okay.
okay.
And then I was coming on to the important case, which is referred to in paragraph 9.5. The proper meaning of the word matters in the mirror image context of section 9, considered by Lady Justice Carr in the Mozambique case. A matter is not the same as a cause of action. It includes any issue capable of constituting a dispute under the relevant arbitration agreement. Ultimately, whether or not a matter is one which under the agreement is to be referred to arbitration turns on the scope of the arbitration agreement, properly construed in context. The fact that fragmentation of proceedings, however undesirable, is often the consequence of the consensual nature of arbitration. For example, in string contracts. And that's the point made in Ruhan. And what are the drawbacks? Just going back to my Lord Justice Nugee's very sensible, obvious question. Well, it's a bit odd if they've got the cause of action. Why can't they go to the end of the road to deal with it? I mean, but that's unfortunately one of the problems about arbitration, is that unless you may have circumstances, of which this is one, where you have what may be called fragmentation. And obviously in England, Lord Hoffman has done his absolute utmost to ensure that doesn't happen. I mean, Fiona Trust rushed away. It was a sea change, breath of fresh air that said, well, basically it's one-stop shop. You know, if you've got a claim, you can have it all resolved in one place. That was a sea change from English law as it was before. And if I may respectfully say so, Iran is oceans away from that sea change. It has a very different approach. And we must be cautious, if I may respectfully say so, as English common law judges, in trying to avoid adopting a pro-arbitration bias when approaching the construction of arbitration agreements governed by a foreign system of law, particularly Iranian law, because the autonomy of the parties, which is what arbitration is all about, means that we must respect their choice of law, even if it's a somewhat alien or odd system of law, when looking at it from our perspective. The Mozambique case, my lords, I've given you the other. I was going to show it to you in the bundle. I've just read the passage. I can give you the references. I just need to sound one slight note of caution, which is that Lady Justice Carr is the clearest on this point, that cause of action and claim does not mean the same as matters. I would say that case went to the Supreme Court, and that there was argument. The argument completed in January of this year. And I've kept a beady eye on the screen to see when the news comes up that the next judgments are due, but I checked this morning and it still hadn't been handed down. Obviously, I haven't seen the transcripts. I did look, or rather watch, I had the pleasure of watching my little friend Mr. Duncan Matthews and others on their feet in that case, but as far as I can tell, there was no debate that what was said about matters was wrong, but obviously I can't say for sure. But it's worth noting that Mozambique is in the Supreme Court. But in any event, my lord, so I explained, ground 3 is a further error, and the effect of it is that it may mean that the learned judge's focus was was on the wrong question, and had he appreciated what he was looking at was a much narrower point in the context of a cause of action, he may well have understood that our Neox case was far more arguable than he perhaps realised. Finally, my lord, ground 4. This concerns the potential relevance of further evidence of Iranian law. And essentially we make 2 points here. First is that had the learned judge focused on what we said were the arguable principles of Iranian law, rather than the 3 he distilled, then it's plain that the further evidence that might be available would assist could assist my clients in helping me to establish more than the 3 he accepted have been established by the evidence so far. So that's a very important error on the part of the judge. But more significantly, in my respectful submission, he adopted the wrong test. And the correct test we would submit is set out in Okpabi, which we looked at once before, but in slightly different paragraphs. It's in volume 3 of the authorities bundle, tab 33. And the relevant paragraphs we submit are paragraphs 126 to 128. It may be that the learned judge below thought that these paragraphs only applied in cases of disclosure, and that's maybe the reason he said in paragraph 61.4, this is not a case in which there is any question of disclosure being given, which might add to or alter the evidence now available. And it's true to say, when you look at Akabi, the heading and the context within which these remarks are made is documentary evidence, i.e. disclosure. But in my submission, the points of principle established by what Lord Hampden says go further than just simple disclosure. Conducting a mini-trial, this is paragraph 126, also led the court making inappropriate determinations in relation to the documentary evidence. Lord Justice Simon appears to have dismissed the relevance of future disclosure on the basis that a good arguable case had to be demonstrated on the basis of the material currently available. And that's not dissimilar in a way to what the learned judge did below. He said, really, you've got your Makrami report, that's the end of it, Mr. Bailey. Don't get home on that, that's it. And across the page, Lord Hampden said, to a similar effect, Lord Justice Simon stated, although the claimants make a further point that is illustrative of what may emerge from disclosure, difficulty is that jurisdiction is founded on a properly arguable cause of action, not on what may or may not become a properly arguable cause of action. This is an erroneous approach. The resolution of the jurisdictional challenge depended on whether the appellant's claims satisfied the summary judgment test of real prospect of success. As Lord Briggs said in Vedanta, quote, the court cannot ignore reasonable grounds which may be disclosed at the summary judgment stage for believing that a fuller investigation of the facts may add to or alter the evidence relevant to the issue. Now, pausing there, my lords, it's that proposition of law, which is not limited to disclosure, which we submit reveals the true test. And I had a long debate with the learned judge below about that. But we would respectfully submit the proper test the judge should have asked is whether or not there are reasonable grounds for believing that a fuller investigation of Iranian law through joint memorandum and cross-examination may add to or alter the evidence relevant to whether my clients had a reasonable prospect of success at trial. And had he asked that question, my respectful submission, the answer is yes. And it's obvious why. From that this wasn't a transparent, wholly hopeless case. This is a case based on complicated points of a foreign law with which none of us are likely to be familiar, where there's no doctrine of precedent. The opinions of the experts and treatises are vitally important, and where Dr. Bakrami had no opportunity to elucidate, and no doubt possibly explain in far greater and more perfect ways than I can, exactly why Iranian law adopts the principles which we've sought to set out in skeleton argument. That was it. We would submit, obviously, a process which would give rise to relevant evidence, which could alter or may add or alter. In the way the judge seemed to put it, is it may add or alter the evidence relevant to the issue. The judge seemed to suggest that I had to show that the evidence was likely to improve my case. And what's interesting is in the next paragraph, 128, Lord Justice Simon did not address this question. The Chancellor did so at paragraph 182, but by reference to a stricter test of whether there is a clear prospect that the new material will become available before the trial, which is likely to give the claimants a real prospect of success. I consider Lord Briggs's formulation the proper approach. In other words, are there reasonable grounds for believing that when he says there disclosure may materially add to or alter the evidence relevant to whether the claim has a real prospect of success. But as we've seen, the test actually expounded by Lord Briggs is broader and relates to a full investigation of the facts, which in our case, of course, means by reference to exchange of experts' reports, a joint memorandum, and cross-examination.
But it's got to be, in order for there to be reasonable grounds for believing that there'll be a material alteration of the evidence, it's got to mean that you would have better evidence as to the prospects of establishing principles of Iranian law than in the existing experts' report that you've got. Because it might be that the other side, contrary to what they've said so far, would take the view that your expert isn't good enough and simply not call anybody, and then your expert's evidence would stand as it is. Or alternatively, I suppose, they might call somebody who says, actually, your expert hasn't gone far enough. In Iranian law is even more restrictive than he said, but it doesn't seem very likely. What's the other possibility? That he may, in oral evidence, say, well, I didn't express myself very clearly in my report, but I can now tell you that principles A, B, and C apply, and they're much more powerful in NEOC's favour than you might have thought when I wrote my report. I mean, where are we in the real world?
In real terms, where are we? Where are we in real terms? Well, the most likely scenario we would submit that has to be taken into account is that Dr. Makrami would have to be cross-examined in the sense that propositions that weren't accepted would be challenged. And the answers he may be able to give in the witness box may, and that's the question, that's the test, not will, may materially add to or alter the evidence that's already provided in a way that provides more guidance to the judge at the trial as to the relevant principles on which we rely in interpreting the contract. I mean, for example, your lordship took me, I think, to paragraph 16.9 of the skeleton this morning. Said, well, actually, if you look at paragraph 26.1, it's a bit obscure. Now, when Dr. Makrami's cross-examined, the clarity of his evidence orally may well be add or certainly clarify the evidence he's put in his report, and therefore, in a case involving foreign law, to ignore that possibility, unless it's obvious that what he said in his first report is wrong. I mean, as Mr. Justice Leggett said, as he then was, obviously there are going to be clear cases. But we would submit this isn't a clear case. This is a complex case involving a difficult system of law, which is not easy for anybody from a common law background to understand. We have a distinguished professor of law, having put a report in. We've sought to do our best as English lawyers to extract from it the principles we rely on, and we should, in our respectful submission, be given the opportunity, calling him at trial, and seeing if the evidence he gives in cross-examination, which we submit it will, not only holds up, but actually enhances our case, and also, whatever limitations, of which there are many in my skills as an advocate, there is at least the possibility I might be able to get some really good answers out of my little friend's expert. I mean, I have managed that in the past in other cases on foreign law. May, not will. I may be able to crack some good answers in cross-examining my little friend's expert.
And the converse, I suppose, is that your opponent's cross-examination is so ineffective that he builds up your expert rather
well,
than
knowing my little friend is to do as well as I do, that's almost certainly not the case.
But are you, because your reliance is essentially on cross-examination of your expert to clarify his evidence, which suggests that the cross-examination doesn't achieve what your learned friend would set out to achieve. In other words, you're assuming you do better following cross-examination, which isn't usually the purpose.
Well, I'm not assuming that. I'm
Or
trying to
you're
address
saying
the may.
that you're saying there's a material likelihood or reasonable likelihood.
I'm just using the
whatever
word
the
may.
test is.
You don't have to show a clear prospect the material will become available or that it's likely to increase the chance of success. Just may.
But it surely must be framed in terms of realistic.
Yes, it must be realistic, absolutely. I accept that, my lady. What I am submitting, and this court will have more experience than me, but what I am submitting, it is realistic to suppose that the evidence that is going to be most telling when it comes to construing this arbitration agreement will be the evidence found within the transcripts of the cross-examination of the two experts on Iranian law. That, in my experience, has invariably been the case, because inevitably one drills down into the detail in what they say in their reports, and either you expose what they say as not being completely accurate, or the expert comes up with a very compelling answer, which either improves or certainly supports what he'd originally said. That is the realistic expectation. And my Lord, it is important, I think, obviously whatever forensic points my learned friend wants to make, fine, but the whole rationale of why my learned friends brought these two applications was because they said there would need to be a hearing with expert evidence on Iranian law and cross-examination, which will last 5 days, and that's the reason why we should have a preliminary issue. So that's the expectation of what would happen if there's a trial. That's the realistic expectation in most submission. Can I think, unless I can assist further, I've almost finished. I've just got one last. I mean, the essential issue, my lords, that the judge should have asked himself is whether or not Neok's argument that the matter or issue or dispute in relation to the putative liability of Crescent to CGNC under a separate contract was a matter which fell within the scope of the arbitration agreement by reference to Iranian law, had a realistic prospect of success on the basis of the evidence that was reasonably likely to be available at trial. That's the question he should ultimately ask himself. And given the nature of the issue, the complexity of it, the fact that the system of law is not familiar, and the fact that Dr. Makrami's report was unchallenged. In all those circumstances, this wasn't a case where it would have been appropriate for the learned judge to, indeed not just appropriate, it would have been the right conclusion for the judge to reach that the case should go to trial. Lord, my lady, unless I can help any further on summary judgment, those are my submissions.
Oh, thank you very much, Mr. Bailey. Mr. Dewan.
My lady, my lords. Can I begin with ground one? Can I begin by giving an overview of my position with respect to the contention that the court engaged in a mini-trial? I submit the court did no such thing. Rather, it focused on the arguability of Neok's construction contention, assuming that Neok could make good the Iranian law principles of interpretation contained in Dr. Makarami's report. That is my overarching submission. We submit that Neok doesn't actually properly or adequately engage with Dr. Makarami's propositions, and that's at the heart of the problem here. We therefore do submit that it is in conformity with the principles of the Supreme Court in Obkabi, and the fact that summary judgment is appropriately to be granted if the claim is not sustainable, even assuming the facts contended for can be established. Just taking a step back for a moment in this overview, the reason why the court concluded at paragraph 59 of its judgment that Neok had no real prospect of success is for a number of fundamental reasons, and I know your ladyship and your lordships have already studied the judgment, but may I just very briefly summarise the points. First, the arbitration clause was drafted in English, not Farsi, and that is relevant, and I'll explain why right now. Second, those words drafted in English were not a term of art or had a technical or specific legal meaning under Iranian law on Dr. Makarami's own evidence. And that is recorded in the judgment, your ladyship and lordships will recall. Now, I say that because some elements of Neok's skeleton nevertheless rely upon authorities concerned with words having a technical meaning in order to assert that it is entitled to rely on Dr. Makarami's inadmissible opinion evidence. That's at footnote 19 and paragraph 25 of their skeleton. But he actually didn't advance any such proposition of the words having a special technical meaning. In other words, you're left with the text, and that's rather important. So applying Dr. Makarami's principles of interpretation, what the court, which provide, and I'm going to have to take you to them, as the paramount, and I'm using his words now, paramount starting point, examination of the words used as reflective of the intentions of the parties. The words, the court concluded, the words used in the GSPC arbitration agreement are wide and amply cover all elements of the claim for breach. And I'll come back to this, what claim for breach means in the context of section 30 and so on in a moment. Now, your ladyship and lordships have obviously looked at the clause, which refers to any dispute, which the court gave emphasis to, dispute, controversy or claim arising out of or relating to this contract, etc. And on their textual meaning, what NEOC, therefore, in my submission, has to demonstrate, and where this appeal stands and falls, is on the question of the arguability of its case by reference to the words used in the arbitration clause, and bearing in mind that this is a matter for the English court to decide after having informed itself of the relevant foreign law principles. That's BNP Paribas, which I'll take you to very briefly in due course. Now, the criticism of the judge that the learned judge discarded the policy rationale for the principles of interpretation being advanced by Dr. Makarami is misplaced in my submission. The judge in terms refers to the restrictive approach in the relevant paragraph of his judgment, paragraph 57, which according to Dr. Makarami is driven by policy considerations. He was therefore assuming the correctness of Dr. Makarami's position. He was not obliged to set out the various rationales for the principle of restrictive interpretation. Now, in my submission, and your ladyship and your lordships raised this point, and I'm going to have to take you through it a little bit. NEOC's skeleton of paragraph 27, which is where they say you should be looking at, involves a misstatement with respect of Dr. Makarami's principles of interpretation. In particular, it's an attempt to interpret words according to alleged policy, even though Dr. Makarami's evidence is that where the words are clear, one does not depart from the words used because the words used are paramount and reflect the intentions of the parties. So one has to get beyond that step one, as I'm going to call it, when I take you to Makarami's evidence, before you go any beyond the words, according to his evidence. And that's, the judge rejected their case at this step one by reference to the words used, applying Dr. Makarami's principles of interpretation. Now, turning to the guidance in Okabe and getting into this a little bit more, there's not much dispute between the parties as to the principles, and I'm not going to waste time on them, save for one point, which is this. First of all, I don't accept that this is a complex point of construction. The point of construction, and of course, when one talks about grasping the nettle, this is a 2 to 3 line arbitration agreement. It's not in my submission, the actual point of construction is a simple one. And that, in my submission, is a paradigm case for grasping the nettle, subject to whatever wrinkles of Iranian law are said to throw out. Now, the second point I want to make is that NEOC submits that you test the arguability of its case by reference to its skeleton submitted a few days before the hearing. Now, as a matter of principle, that cannot be right, my lady, my lords. It's of course, we are of course dealing with a Part 8 grounds of claim, and your ladyship and lordships will have seen it's a very detailed grounds of claim. And you may recall that Mr. Justice Coleman in the Azov shipping case, and I can take it to you if it's helpful, but it's a simple point. He says, even in a Part 8 claim form, best practice is actually to plead your points of foreign law, in that case Ukrainian law, with your Part 8 ground.
Well, essentially, the Part 8 ground, the arbitration claim form, adopted Dr. Makarami.
Exactly. So so my point is that you look at Mokarami. So by all means, one can test Mokarami by reference to paragraph 27 and ask one the question, which I would submit is the answer, which is some of the propositions that they're putting forward in paragraph 27 are demonstrably unsupportable by reference to Mokarami applying the Opkaby test, because if they're demonstrably unsupportable, you don't go into them, but it's important.
So you mean demonstrably unsupportable in the sense that they're not what Dr. Mokarami says?
Yes.
Rather than that he says it, but they're wrong.
Correct. In the sense that he doesn't say what they say he says. Well, one of the points your lordship picked up on was one of the paragraph references, and I'm going to take you to 5, which I say are demonstrably unsupportable by reference to his propositions, which explains why the court said at paragraph 58 of its judgment, after 57 where it set out the principles, at 58 the court was very careful. It said, I've gone through the cases, I've gone through the text, there is nothing which supports any further principle of interpretation beyond what I've set out in paragraph 57. And that's quite important. Now, just for your reference, your ladyship and lordships will recall the Brownlee against Cairo case on foreign law, proof of foreign law presumption and so on, 2022 appeal cases 995. We don't need to take it up right now, although I will come to it. Volume 1, tab 8. But I just want to remind the court that in that case, foreign law, it was a Part 7 claim, jurisdiction, service of jurisdiction outside of, service of claim form outside of jurisdiction. That was a Part 7 claim form. The principles of foreign law had not been pleaded, but there was an expert report, and so the court looked at the expert report to see what the principles of foreign law being relied upon were, and what gaps in that foreign law evidence there was, and how you go about gap filling. And that's so in other words, that's exactly what the court did here. The expert report was appended to the, as your lordship just pointed out, appended effectively to the Part 8 claim form, and so the port of call was the expert report. And that's exactly what happened in Brownlee. That's at paragraphs 101 and paragraph 105. So my submission, just on this first point, in my submission, the court had no choice but to go to the expert evidence to identify the principles of foreign law that were being relied upon, those not having been set out in the claim form, the Part 8 claim form. Now, so in terms of Dr. Mokarami's principles of interpretation, I do forcefully submit that paragraph 27 of Neox Skeleton contain a number of glosses and additions that are not supported. So I'm going to spend a little bit of time on this. I want to start with Dr. Mokarami's report. I'm going to look at it in the core supplemental bundle, if I may, at tab 4. There's only a few paragraphs which actually deal with the principles of interpretation, and it's quite important that we look at them and then compare with paragraph 27 of Neox Skeleton. So the first point, I'm starting at paragraph 22, if I may, which is on page 14. So the first point is that paragraph 22 says the starting point under Iranian law, this is at page 14, paragraph 22, is the words of the arbitration agreement itself. This is because the words of the arbitration agreement are paramount, and I emphasize the word paramount in conveying the mutual intention and consent of the parties. Now my headline point, though, is going to come when we look at paragraph 23, and Lord Justice Males has already identified this point, if I may say, which is if we go to paragraph 23, first sentence, Iranian law has a restrictive approach to interpreting the scope of the arbitration agreements. But the key point is, what does that actually mean? because with respect, New York keep talking about applying a restrictive interpretation, but then don't go into what that actually means in my respectful submission. So what's said first is the rationale for this approach is the arbitration derogates from the default jurisdiction of the Iranian courts. Accordingly, a third line, under Iranian law, there is a presumption that jurisdiction is only conferred on to arbitrators resolve those specific claims, disputes, or controversies that the parties have expressly agreed and articulated in the arbitration agreement. So in other words, first port of call is the words used with the presumption being only on those claims, controversies, disputes that the parties have articulated. But bear in mind also that there is no special meaning to be given to words used, because that is not something Dr. Mokarami advocates. Now, and then, when do you go beyond the words? So what I call I talked about step 1, which is textual interpretation. Then, what I call step 2, which is last 3 lines, it follows that if there is any reasonable doubt as to whether a particular dispute or claim or controversy comes within the scope of the arbitration agreement in question, it is generally, and I emphasize the word generally, not absolutely, generally determined against the tribunal having such jurisdiction. So textual approach, look at the words used, with any doubt generally, but not absolutely being resolved against coverage in step 2. And if we go to paragraph 29, I emphasize what is said here, which is effectively a repeat of paragraph 23. The scope of an arbitration agreement can in principle be subject to interpretation, as the examples given immediately above demonstrate. However, an arbitration agreement, like any other contract, is only subject to interpretation under the principles of applicable law, where there is an ambiguity in the text of the agreement. If there is no ambiguity, the text is strictly interpreted. So again, you look at the text, you strictly interpret it. If there's any ambiguity, then there is scope for applying a presumption against coverage, generally, although not absolutely. And then at paragraph 32 and 33, what is also made clear is that you do have to distinguish between words like arising under or in relation to, because Iranian law does not apply a Fiona Trust presumption. Now, there are a number of rationales which I'm going to come back to for these principles, which are explained in Dr. Mokarami's report. There are a number of underlying rationales which are explained, but they are the rationales for the approach. They're not principles of interpretation. So, pausing there, my submission, paragraph 57 of the court's judgment is an accurate summary of the principles of interpretation. And what happened here in paragraph 59 is that the court didn't get beyond step 1 because it concluded that there was no real prospect that on the words used, that the claim concerning a third-party liability, which was a direct and foreseeable liability on the merits findings of the tribunal, which I'm going to come back to, did not fall within the scope of the arbitration agreement. So questions of ambiguity and application of that principle simply did not arise. That's why I say the question is, the real question of arguability is whether on the words used, NEOC has a real prospect of establishing that the claim in question falls outside the scope. Because unless it can establish before this court that the court was wrong to conclude that the claim was clearly within, then it's going to fail. but it actually isn't advancing a case to that effect. What it's saying is that certain principles were not taken into account. So I do want to therefore go to Neox paragraph 27. But before I do that, your ladyship and lordships were taken to a text from Shiravi, which was said to demonstrate these principles, or at least support some of these principles. Now, can I just take you very briefly to it? Because I just want to remind you what you may have picked up on this already, but if we go to the core supplemental bundle at tab 5J, I just want to remind you, because the judge did pick up on this point in paragraph 58 of his judgment. You'll see in paragraph 58 of his judgment, he refers to an article by Dr. Shiravi, and it says, the article expresses the view that while a clause which referred to arbitration disputes arising out of the contract might not cover disputes as to its formation or validity, a clause which referred to all disputes related to the contract shall be construed as more extensive. This indicates that Iranian law mandates that attention is given to the words used. Now, if you go to the Shiravi article, page 102, I just want to rely on a few passages which in my submission were very accurately summarized by the court. So line 2, the fact that these disputes and claims are wholly or partly the subject matter of arbitration depends on the words and expressions used in the arbitration agreement. The arbitration agreement may broadly cover all the disputes and controversies, or it can only submit a specific claim. And then you were taken to the bits from about the 9th line from the bottom, where a comparison is made between a clause which talks about a dispute arising out of the contract. That's about the 9th line from the bottom. And then if we look at the 3rd line from the bottom, while in case it is stipulated in the contract that all the disputes related to the contract shall be referred to the arbitration, such a stipulation shall be construed as more extensive. And then it talks about standard form wording in order to deal with these problems. So typical ICC or UNCITRAL and so forth clauses. So in other words, yes, no, fear, no trust presumption. But beyond that, you're just left with the words used. And it's only if there's any doubt on the words used that a restrictive interpretation may apply to exclude the matter in issue from coverage of the arbitration clause. Now, can we compare that with what NEOC has said in its skeleton? So I want to go to Core 1, paragraph 20. So this is tab 2, and I want to look at paragraph 27, which is, I think, what was called the principles of interpretation, the 11 principles. Now, the first point I want to make, if I may, and forgive me for this, but it may be helpful to keep Dr. Mokarami's report open at the same time, just to compare. So, the first point I want to make is at subparagraph 3. What NEOC says here, it is a fundamental policy and principle of Iranian law that arbitration agreements are construed to avoid any risk of inconsistent decisions. And it gives the rationale. Accordingly, Iranian law construes arbitration agreements narrowly to avoid this risk. Now, can we just look at what Dr. Mokarami says at paragraph 30? Which is on page 17 of the core supplementary bundle. Now, he talks about the risk of inconsistent decisions, and he says in the last line, this rationale, the importance of avoiding such risks, further substantiates Iranian law's restrictive approach to ascertaining the scope of the arbitration agreement. Now, So this is a policy rationale in my submission, underlying the restrictive interpretation, but adds nothing to the circumstances in which it is engaged, beyond the paragraphs that I've already taken you to, being paragraphs 22, 23, 29, 32, and 33. At step one, one engages with the words. This policy rationale has no further role to play. And so when it's said that you construe arbitration agreements narrowly to avoid this risk, with respect, that's going further than what Dr. Makarami is saying. Because if the words cover the claim, you stop there. Now, if we then go to paragraphs 27, 4, and 5, of the skeleton argument, what is said here by reference to civil procedure rules, and I'm looking at the fourth line, in the context of a dispute between A and B, the tribunal cannot determine issues between B and a third party C in the absence of C. This right exists and falls to be protected, notwithstanding the fact that an arbitration award is not binding on a third party such as C. That's what is said. And you'll see that there's actually no reference to Dr. Makarami's report to support that, but a reference to a judgment, which the court extensively dealt with. Now, if we go to Dr. Makarami's report at paragraph 39, page 19, you'll see what he's dealing with the privity of contract and the limited circumstances in which a third party can be joined to the arbitration. And what he says is that this principle in the last three lines is consistent with the fact that arbitration agreements are subject to the principle of privity of contract, and it reinforces the generally restrictive approach to the construction of such arbitration agreements. And then he footnotes that case that they refer to. But just pausing there before I take you to the case, he again is saying it's just the principle of privity is a rationale or policy that supports his principles of interpretation. Now, in terms of what the judgment actually stands for, the court analysed that judgment and its additional reasons in some detail. Your ladyship and lordships may recall this, but let me just remind you, and then I wouldn't mind taking your ladyship and lordships to the actual judgment. But if we go to the additional reasons, which is in tab 13 of Core Bundle 1, you'll see from paragraph 14.
Sorry, which bundle?
I do apologise. Core 1, tab 13,
yes,
page 142.
Thank you.
Now, just recall what has been said in the skeleton argument, which is that this stands for a proposition that this right exists and falls to be protected, notwithstanding the fact that an arbitration award is not binding on a third party such as C. Now, the judge at paragraph 14 went into some detail into this judgment, and if we go over the page at 143, he summarises what the judgment says. It also because what is apparently said by the Court of Appeal is that it would not have been in accordance with the arbitration agreement for the tribunal to decide on certain matters relating to dealings with the third party, and that the third party's rights could not be impaired, and that the third party could not be implicated and joined to the arbitral process without its consent. This seems to be reasoning as to the construction of the arbitration clause in that case, and that a tribunal cannot make a binding decision on the rights of a third party. The first would be relevant if at all to issues of construction, but does not appear to deal with the meaning to be given to words such as arising out of or relating to, nor does the court say that there is a generally restrictive approach to the meaning of arbitration clauses. Second matters a principle which is not infringed by the tribunal having jurisdiction to decide on the CGC liabilities to CNG's losses claim for the reasons given in paragraph 555 of the partial award. So where my NEOC says that it's talking about you can't even deal with issues concerning a third party with non-binding effect, this is not supported by Dr. Markram. He doesn't say anything of the sort, and nor does this judgment. And I'm happy to take... There has to be identified, in fact, for the purpose of this appeal, an error in the court's analysis of the judgment, technically speaking, but I'm nevertheless happy to take you to the judgment if it's going to be of assistance for this point. Let me show it to you. Let me give you the reference. So it's in core supplemental bundle, tab 4P. Oh, 5P, apologies. So if we start at page 152, this is the first instance judgment. You'll see from the second paragraph of page 152, beginning with the words first, you'll see the beginning part of this agreement reads, and it talks about financial disputes between Mrs. MH and AP. And then you'll see, which is why the judge said what he said, reading further down, starting with the words obviously, and given the fact that the word should be construed based on their appearance, the parties to the arbitral agreement have been only the natural persons, namely the claimant and the respondent, i.e. Messrs. MH and AP. And then in the next paragraph, this means that a third party to get involved or to join any third party to the arbitral proceedings presupposes the conclusion of a new arrangement. So that's traditional consent points. Now, on the next page, page 153, this seems to be what caused the jurisdictional issue, which is under second, in view of this court, even despite the silence on the part of the claimant, the arbitrators lacked any contractual or legal authority to consider previous financial dealings between the respondent and the foreign company ASH, the existence of which is undeniable taking into account the contents of the case. Because the claimant lacks any legal standing in the said company, on the other hand, said company has by no means any relevance to the arbitration agreement. In other words, the dispute concerning the LCs have not been brought against its issuers. So what seems to have happened is that an attempt was made to bring a dispute involving a third party within this arbitration agreement. And if you look at page 154, Judgment of the Court of Appeal, under Judgment of the Court of Appeal at the bottom, reading from the fifth line, the reason is that the arbitration agreement is only effective as to the parties to the arbitration agreement, and the appointed arbitrator is authorized to only declare his opinion and verdict with respect to the parties to the said agreement. Any action and ruling by the arbitrators vis-a-vis third parties, reading on, is against the parties' will and intent. Now, just pausing there, it's worth bearing in mind that Dr. Mokarami cited multiple authorities for the proposition that an award between A and B does not bind C. Multiple propositions. I can give you the references, we don't have to take them up, but multiple. CS, core supplementary bundle at tab 4F, 4H, 4I. Now, that sits inconsistently, fundamentally inconsistently, with the gloss which I submit NEOC is putting, which is that even where there's no binding effect on the third party C, you can't deal with any issues which concern a third party, because if that were true, then you don't need a principle of Iranian law, which Dr. Makarami cites, which is that an award between A and B is not binding on C. You don't need that principle. It's irrelevant. Now, if we then go back to NEOC's skeleton argument at 27.8,
Are you covering both 4 and 5?
I have, because they're sort of the same thing.
I think. I see. Okay.
Apologies, I should have made that
Yeah,
clearer.
you did mention 5 earlier.
So I don't have a problem with 6 and 7, because that's what Dr. Makarami does say. Then 8, this is, what is said here is that relating to means sufficiently connected as a matter of Iranian law. And reference is made to Article 141 of the Iranian Code of Civil Procedure 2000. You see that? Now, it's true that Dr. Makarami does seek to rely upon that provision. Can I, which, if we go to his report at paragraph 27, But all he's, let's just be clear what he's doing in paragraph 27. All he is doing is relying upon a rule of court procedure, and I'm going to show you the rule of court procedure, on the filing of counterclaims for his inadmissible interpretation of relating to. This is not a principle of interpretation. And if the relevant provision is in 5N of the same core supplemental bundle, it has nothing to do, and therefore would be demonstrably unsupportable as a principle of interpretation, and that's in any event not what Dr. Makarami is saying. So Article 141 at page 143, the respondent can file a claim against the claimant if such a claim arises from the same origin or is fully related to the original claim. It's called a counterclaim. And then in the second paragraph, there's complete connection between two disputes when deciding on whether either the claim is effective on the other. So that's a rule of court on the connection between a claim and a counterclaim, which is being relied upon by some form of analogy for the purposes of Dr. Makarami's actual inadmissible interpretation of the words relating to. If we then can turn to 27.9, a tribunal's jurisdiction would only extend to the resolution of issues or controversies arising under another contract if it was specifically mentioned in the arbitration agreement. Now, this, with respect, is again not a principle. So if we go to 26.1 of his report, this is not a principle of interpretation. This is just him building himself up for his own interpretation of the contract. it's not a principle of interpretation, and therefore, what was the court meant to do with that for the purposes of asking the question of the arguability of the claim? Now, the final point is on if we go to little 10, 2710, you'll see there the point is being made that when a specific contract is mentioned in the arbitration agreement, the tribunal's jurisdiction will cover disputes which arise directly under that contract, but will not extend to such disputes, controversies, or differences which arise indirectly out of the contract. Do you see that in the skeleton argument at 2710? Now, that fell into another problem which the court ruled on, and which is not the subject of this appeal, which is 26.3 of the Mokarami report. If you look at it, you'll see that it refers to Article 520 of the Code of Civil Procedure. Damages can only be claimed or awarded where they are the direct result. In the case at hand, and I want you to bear this in mind for other propositions that we're going to come back to, which also actually feed into something that Lord Nugee said previously. In the case at hand, as a matter of Iranian law, any damages allegedly suffered by CNGC are not a direct result of the breach of obligation between NEOC and CGC. So what actually is being said by Dr. Mokarami here, and just bear this in mind, is that the entire claim is indirect and therefore falls outside the scope of the arbitration agreement as a matter of his opinion.
This was decided by the tribunal.
And exactly. And so the court said you can't, because it's a merits finding that it was a direct loss. The CNGC liability was a direct loss. And the court therefore said we complain that cannot be reopened, a merits finding of the tribunal. And Mr. Justice Butcher therefore said that this was inconsistent with a merits finding and therefore could not be relied upon. But 27...
And that's not been appealed.
No. So 2710, but you're still advancing that proposition. Well, I've already addressed mine. So just for your note, the Remedies Award addressed these points and concluded that the CNGC liability was both direct and foreseeable and the natural and ordinary consequence. So this is Core Bundle 2, tab 17, at paragraphs 563, 572 and 574. Now, the other point that is made is that NEOC has submitted that notwithstanding what Mustel and Boyd says, there is a credible argument for saying that in a contract between A and B, you have no jurisdiction to determine the liability of A to C under a separate contract, even if it's with non-res judicata effect. Now, just to be clear, so in other words, it's not arbitrable. Now, Dr. Mokarami is not saying anything to support that proposition as a matter of principles of interpretation. So, in my submission, Mustel and Boyd is completely irrelevant. I would also point out that from an English law perspective, to the extent it's relevant, the idea that the Mustel and Boyd proposition is controversial at all is a surprising submission to make. In Arsenovia, Mr. Justice Andrew Smith said it was obvious. So a typical example, a guarantee. A guarantee might bite once depending on a liability under another contract. And he gives that example and says, well, of course you can determine whether there's a liability for the purpose of seeing whether the guarantee bites. So as a matter of English law, to the extent that's relevant, not controversial at all. Now,
Mr. Justice Popplewell says the same thing in Ruhan.
indeed. Now, so the only other points that I want to pick up on. So in other words, in my submission, all that's happened is that they're trying to bring in, just wrapping this up, they're trying to bring in underlying rationales for the approach to interpretation as being directly applicable to the words used. And Dr. Mokarami says no such thing. And even assuming that they can establish his propositions, at step one of his analysis, you look at the words used, as the judge did. And I'll come on to this concept of literal, because that's a separate ground. But you look at the words used, and you ask yourself whether or not the claim matter falls within. And you don't get into any questions of the ability to apply a presumption against arbitration jurisdiction if there's no ambiguity. And he concluded that there was no ambiguity. Which is why I submit the arguability turns on them being able to demonstrate by reference to the words used that there is an issue of arguability. And that the court was therefore wrong to conclude otherwise. If we then can, so if we go to paragraph 25 of Neox Skeleton, this was the point I touched upon in my opening remarks. The opinion of an expert that words have a particular or special meaning under the relevant foreign law is admissible. Now that's true as a proposition of law. The problem, as I said, and again, this hasn't been challenged on this appeal, is what the learned judge said at paragraph 55. Dr. Mokarami does not give evidence to the effect that the English words, or equivalent arising out of or relating to, or indeed equivalent words in Farsi, are legal terms of art or have a technical meaning. And so the cases, such as the Châtenay case, are just irrelevant in this situation. And in fact, the decision of Mr. Justice Leggett, as he then was, in the Maud case is also relevant because what was being contested, not only was the court considering a contested issue of statutory interpretation of the provision of the Insolvency Act, but what was being said by the party seeking summary judgment was the wording of the statute had a special meaning, and they referred to a Supreme Court judgment, but we're not in that territory at all. So, the relevance of paragraph 25 of Neox Skeleton is not clear to me, but in my submission it doesn't take them anywhere. And the only final point, but the court already has this firmly in mind, but I think it's worth just wrapping up with this, which is the BNP Paribas Court of Appeal decision of Lord Justice Hamlin, as he then was, on the role of foreign law expert evidence. Because in my submission, what it does is emphasizes why, in this area of the law, when it comes to principles of interpretation, given that the limited nature of the exercise of the foreign law evidence, which is just to give the court the principles of interpretation, it is particularly ripe for summary judgment. So this is Legal Bundle 1, tab 7. And the relevant paragraphs, I know the court is very familiar with this, obviously. From paragraph 45 at page 110. So, paragraph 45, I emphasise the fact that the role of foreign law experts in relation to issues of contractual interpretation is a limited one. And that's the point why I say this is an area which is fertile potentially for summary judgment. It is not the role of such experts to express opinions as to what the contract means. That is the task of the English court having regard to the foreign rules of interpretation. And then 49, obviously TRM's Italian law expert did express views as to how an Italian court would interpret the IJC. That is inadmissible and irrelevant evidence. And the point I would make here is that one of the points NEOP makes in their skeleton, although not pressed, particularly orally, was that, well, that was a matter for the trial judge. But the point that Mr. Justice Butcher was engaged with was, assuming you can establish your principles of interpretation, what would be the result? And obviously the opinion evidence is not something, he didn't strike it out, he just observed that it contains multiple references to inadmissible opinion evidence. So he wasn't making findings or determinations, he just observed that in the context of extracting the principles of interpretation. Unless the court has any specific questions, in my submission, just to wrap up, he identified the principles correctly, and he was obliged to do so, there being no pleading of foreign law being put before him. And he did not, therefore, engage in any mini-trial. He wasn't concerned with questions of making findings, but assumed that NEOP would be able to make good the propositions being advanced. And that's all I was going to say on ground one.
Yes?
Ground four.
Could I just ask?
Yes, please.
Ordinarily, in an application under Part 24, which involves no question of foreign law, the court will decide points of construction if it feels, if it's confident it has all the material available,
Yes.
and that it's appropriate to do it at that stage.
Yes.
That's the grasping the nettle
Yes.
point. Is it any different if the document that has to be construed according to some foreign law, and therefore the court is embarked on a less familiar process of using the expert evidence as to what the foreign law principles are to reach its view on interpretation? Should you be more hesitant grasping the nettle in those circumstances?
As a matter of principle, I can't see why, unless there's a question as to what the principles are. And the reason why I say that is because of the role of expert evidence in this context, which I've just been taking you to, which is ultimately it's for the English court to decide the question of interpretation. In other passages, Hamblin, Lord Justice Hamblin, as he then was, points out that it's irrelevant to start asking oneself the question of how would the Italian court decide the question, because you are equipped with the principles of interpretation, and then it's for the English court to do it. So I can't see as a matter of principle why there should be any hesitancy. The hesitancy can only arise if there is, first of all, where there's contested expert evidence as to the principles of interpretation. That's where I can see hesitancy, which was the situation in Mr. Justice Leggett's case. But otherwise, ultimately, it will always be for the English court, without reference to the opinions expressed by the foreign expert, except in a case where special meaning is an issue, as was the case, again, in Mr. Justice Leggett's case.
Thank you.
Now, I was going to go, my lord, may I ask an impertinent question? What time were you planning to rise today?
We'll rise at 4:15.
4:15, thank you. I was going to go on to ground 4. Forgive me for taking it out of order, but that's it seems to me the back end of the mini trial point, which is the idea that something else may improve the case, or that further evidence may become available sort of point. Now, so it's quite important here to have the court's judgment again back at tab 11 in Hall 1, paragraph 61. And this is ground 4, the complaint that the judge was wrong to consider paragraph 61 of his judgment, that there was no reasonable ground for considering that if the matter were to proceed to trial, the position of NEOC on Iranian law might in some way be enhanced. Now, we say that this complaint amounts to unprincipled McCorberism with respect, because it's a speculative hope, in effect, that something might show up that is inconsistent, in my submission, with the proper administration of justice and the very purpose of summary judgment. So, applying the Ockerby test, I submit the judge was entirely right to conclude that there was no reasonable ground for believing that a fuller investigation would add to or alter the evidence relevant to the issue, so that the position would be materially different. There has to be materially different. And it's worth bearing in mind the points that Mr. Justice Butcher marshalled at paragraph 61. The first is that obviously this is a very long-standing arbitration which has gone on for 13 years, with every point of Iranian law being addressed in the underlying arbitration. So, in other words, NEOC had considerable expertise and familiarity in adducing Iranian law. And therefore, little 2, there's no reason for thinking if there were to be a trial, the principles would be shown to be more favourable. And if one goes to 61.2, Mr. Bailey Casey is recorded as accepting that NEOC was not contending there was something which Dr. Rami wished to add to, which was not in his report. So just in terms of, in my submission, that's quite important, because Lord Justice Nugee made the point, well, what happens at a trial? And so the question is whether the expert comes up to proof on his evidence, in my submission. And so if there's nothing else to add, the most that can happen is that the expert's evidence comes up to proof. If the contention is that, well, it can always be improved by another expert supporting that proposition, or by answers given in cross-examination, in effect, with respect, that means you cannot get summary judgment on foreign law, it seems to me, because otherwise you can always make this point. There has to be a principled basis, in my submission, for considering that there could be a material change to the evidence.
Material change for the better.
For the better.
Because material change for the worse doesn't assist you.
Exactly. There has to be some benchmark for believing that it will be what Mr. Justice Butcher talked about in little 5 would be materially different in a way which favoured NEOC. Because otherwise all you're doing is coming up to proof on your evidence.
And to follow up the distinction you were drawing earlier, what would be needed would be not just further support for the rationale for the principles, but an additional principle.
Yes. That's what I would submit. But it was confirmed specifically because that there was nothing new. So we do submit that this is at a level of speculation which is unprincipled. But there's another point here which I want to put to the court, which is this. The assumption built into this hypothesis is that with respect to the foreign law expert evidence, the court would in fact give permission to call experts on principles of interpretation. There would be an opposing expert that Crescent could and would call. And I know my learned friend said that we had indicated that we would be submitting expert evidence. I'm not aware of anywhere where we've made any such indication, just for the record. But
I thought you said that the reason why it was helpful to have a preliminary issue is because there might otherwise be a 5-day trial, which does tend to suggest that there would be
we didn't commit
of the evidence.
Well, we haven't ever committed to calling expert evidence, is my only point. I can see what the point your lordship is putting to me, which is the point about the summary judgment is that it would obviate the cost and expense of a trial. But there is a point here, let me try and explain it, which is that we've got the judgment of the Supreme Court, and your lordships will all tell me if this is a bad point, I'm sure, that we've got the Supreme Court's judgment in Brownlee and Cairo, which has to some extent done away with the old concepts of how foreign law is to be proven, which is that it can only be done through expert evidence. But the old notion was that it had to be proven through expert evidence, and Lord Leggett at paragraph 148 of his judgment said that's not correct. That you can also do it through text, through exegesis of articles, case law, and so forth. Now, my point is, if one looks at the Commercial Court Guide on this, and I put it in the bundle, you'll forgive me for making this point, but if we go to Legal Authorities Bundle 5 at tab 59, H 3.1. So the point, I just want to, what I'm trying to get at is the idea that the evidence will be improved through cross-examination and so on, has a further level of potential speculation in light of the rules on expert evidence. So H 3.1, expert evidence of foreign law features in a significant proportion of commercial court trials. Foreign law is a matter of fact to be proved by evidence, but CPR gives the court flexibility in determining how the content of foreign law is proved at trial, and then it refers to the Brownlee judgment of the Supreme Court. And then if we look at H 3.3, the points I wanted to emphasize was little b and little c. The court can direct such an exchange of reports, but on the basis the experts will not give evidence at trial, although the evidence is not agreed, or do so only on some of the matters covered by the reports, although their evidence on other matters is also not agreed, with the advocates making submissions at trial by reference to the reports. And C, the court can limit the expert evidence to identification of the relevant sources of foreign law and of any legal principles as to the interpretation and status of those sources, with the advocates making submissions. So my small point is it's unprincipled speculation to assume that Dr. Mokharam's evidence would be improved through a trial and through cross-examination. And there's a further wrinkle or level, which is that's assuming it will be called for cross-examination as opposed to submissions being made on the principles. Now, I've effectively already dealt with the Edgeworth Capital and Maud case. That's Mr. Justice Leggett's decision, which is at volume 1 of the authorities, tab 16. And as I say, that's a vastly different case involving a contested issue of statutory interpretation. And so where the applicant for summary judgment was seeking to contend that the statute had a special meaning, which was different to the literal meaning of the words. So in my submission, it doesn't really take the court very much further. Because that's a vastly different situation to one where you're just testing it by reference to one party's principles. It may be worth taking, Your Lordship, just to show the statutory point in issue. So it's volume 1, tab 16. So if I can just, the relevant bit is at page 390. It's worth just pointing out what the issue was. So if you go to paragraph 7 at the top, they were concerned with Article 97.2 of the Insolvency Act. And you'll see that it says, if the creditor classified as specially related to the debtor on the creditor list does not challenge against that ranking in the timely and correct manner, the Insolvency Court, on expiry of the time for challenge, and with no further formality, shall hand down an order declaring that guarantees of any kind be extinguished. So a person who had given a personal guarantee, who was resisting summary judgment, was saying, it says any guarantees, so they're all extinguished. And the applicant to the summary judgment application was saying, well, actually, this provision has a special meaning. It only applies to in rem guarantees, not personal guarantees, and there's a Spanish judgment to that effect. And you'll see this at paragraph 12. So you'll see that the applicant to the summary judgment application, line 4, Mr. Phillips argues that the literal interpretation of Article 97.2, for which the defendant contends, cannot be and is not correct because it would result in absurdity. And then he goes on to this. And it's in this context that Mr. Justice Leggett, as he then was just persuaded not to grant summary judgment. Contested issue of Spanish law, where what was being contended for was against the literal wording of the contract. Statute, apologies, which is also different.
When the court's construing a foreign statute, does the same apply as when it's construing a foreign law of contract? You only produce evidence of the principles?
No.
No, you ask what the Spanish court would make of the law.
That's my point, which is that it is different. The exercise is different because it's more extensive.
So is the difference then that the exercise is different because you're doing different things when you're construing a Spanish statute, or is it that it's a case of a special meaning of particular words in the statute?
So I think the answer is both, isn't it? Because not only do you can get opinion evidence on the meaning of the statute, but what was also being contended for was the statute did have a special meaning, which was different to the literal meaning, which referred to all guarantees. So it's a different task to interpretation of a contract, but in addition, in terms of the special meaning, you can see this from paragraph 14, for example. It's perhaps inapposite of me to use the word special meaning because I think with respect to your lordship was right to pick me up on that. I'm perhaps using that inelegantly and not precisely enough, because in the context of a contract, when you're talking about special meaning of words, that's one point. When you're talking about literal interpretation versus the actual interpretation of a statute by reference to its policy and so on, that's not necessarily about giving special meaning or not. It's about interpreting it according to the canons of construction relevant to a statute.
Yes.
So, your lordship has correctly picked me up in the sense that the exercise is fundamentally different.
Yes, I see that.
But it might be the case that there could also be a special meaning in a statute,
Yes.
which would then overlap
Or in a contract.
or in a contract.
Could
The
have
two could overlap.
a particular term of art being used, which the foreign expert could explain to the court.
It was also a case where the expert, he had two experts.
There were
Mr.
two
Justice
experts.
Leggett, and they gave different views. And
They did.
his actual decision is, well, how can I, whatever I think at this
Yes.
stage, I'm not going to resolve
Yes.
the difference between them.
My lord, indeed, which is why it was a contested issue of foreign law, as opposed to an assumption that the foreign law principles would be established as articulated by one side. My lord, that was all I was going to say on ground 4.
Right.
I'm now on to ground 2. I'm not sure if it's not very long, but I'm not sure whether it may be more convenient to adjourn now.
Yes. All right. Well, let's do that, but just take stock of where we are. How long do you think you're going to need to
Not
complete
long.
the response to the appeal?
So, I would hope 20 minutes.
Right. So, a pretty good chance we might finish the whole case tomorrow.
That would depend on whether you're, if the court is going to reject my cross application on the basis that there's no jurisdiction, then certainly. If the court was against me, if the court either reserved judgment or decided there and then that there was jurisdiction, and therefore we proceed to the cross appeal, I don't think realistically that would be finished tomorrow.
No. All right.
I hope.
Yes. All right. Well, we'll see where we go. All right. Thank you very much then. 10:30 tomorrow.
Court is able.